If I can't take up the matter, what can I do?
My lord, oblige me.
May it please, my lord. Beg to mention items 28, 29, 30, 31 of today's daily list, my lord. I seek adjournment for the day, my lord.
Why?
Senior advocate Mr. Diganto Das is out of station, my lord.
Lordship,
He's in ISO and
Lordship,
one affidavit was also.
the petition in this matter, Your Lordship, we are not given any consent to this.
My lord, we had already taken consent, my lord, with due respect. And one affidavit was also served upon us, my lord, yesterday.
Reiterate when the matter is called.
Lordship, additionally, the addition affidavit may call for Lordship will find an addition affidavit.
My lord, I had received.
It is those selection matters in.
Lordship,
My-
Cotton University.
We heard this matter.
My lord, with due respect, we had got consent from the other side, my lord, yesterday evening.
Fine, there is a consent, but he is objecting. So not at 10:30 when the matter is called up, we will pass orders.
Highly obliged.
May I please, your lordship? Lordship, with the consent from the other side, I beg to mention item number 11 and 12. As my senior Mr. S. Committee is out of station.
I hear for the petitioners.
As agreed to by, as prayed for by the learned counsel for the parties, registry to list these matters again after the ensuing vacations. 14, 12 matters.
Sorry.
Right, please, your lordship. Lordship, I beg to mention this for listing of matter tomorrow.
My lord is saying, my lord,
Make
Joint
it,
Lordship,
Lordship,
my
item
lord.
number 45, 46 and 48, my lord. My lord, NMC is yet to receive the instruction. In that case, can it be listed after 10 days or 2 weeks, my lord? These matters are
45,
45, 46 and 48, similar matter
Similar.
relates to examination.
45, 46 and 48 as prayed for by the learned counsel for the parties, registry to list these matters after the ensuing vacations.
Obliged.
obliged, my lord. Deeply obliged.
Hey, Sharma, somebody visible in the yes, Sharma. Data locks on it. Mr. Samoa.
Yes.
There is a mention made by Ms. Sharma. When do you want these matters?
My lord, they were supposed to produce a document.
I'm sorry, I don't know why. Mr. Chaudhary, Mujumdar is having some problems. Mr. Chaudhary, second, please. 1 second.
My lord, in this matter, I am appearing WPTPC is no more there, my lord. I have just received the instruction.
Forget it. I just want a notification whether these villages are included in
My
that.
lord, that instruction is being verified, my lord. I have just received a call from.
Those
the
matters are pending from 13. If you have not been in a position to verify, we will exclude them. That's all.
No, my lord, that is not the thing. My lord, try to understand my position. That department is no more exists. All these files, my lord, has been scattered, my lord. It has gone to different departments. So now they are trying to trace it. They have almost traced the file. So in a day or two,
How? By way of satellite?
not satellite, my lord, by cause, my lord, cause that those files, my lord, in which now it has gone to tribal affairs department, my lord. It has been not that, so now there are 4 departments out of the 3 departments, my lord, from this one department. So which file has gone where?
We don't know anything.
So my lord,
Mr. Mojumdar is appearing.
yes,
He is having some difficulty. One more date I'll give. After that, whatever is there, we will proceed and pass.
my lord.
When? Before vacations.
Yes.
Monday, Tuesday, Thursday, next Thursday.
Thursday.
Subject to the deeply obliged.
And this time, I'm sorry, I'm not going to
My lord,
exonerate.
yes.
My lord,
We are, if you don't have that materials, we will allow, we'll exclude, do whatever you want to do.
my lord will just show my name as WPTBC, my lord, in the causeless manner.
I'm giving you a date today.
My lord, yes.
I'm giving you a date today. Your junior will take it down. 3 to 10. As a last chance, the respondent state, last chance to the respondent state to produce the notifications issued while initially constituting the Rabha Hassan Autonomous Council area last chance is given to the state respondents to produce the notifications issued towards initial notifications issued towards constitution of the Rabah Hassan
Autonomous.
Autonomous Council to verify as to whether the villages involved in the present proceedings were also included within the said council area. Also, a list as prayed for, list this matter again on. We'll have it on 26th.
Mine.
26th.
26th of June.
June.
My lord. We all Goodbye. Deeply obliged.
My lord will just reflect my name, my lord.
Name of Mr. R. Dot Learned, additional senior government advocate be reflected in the cause list.
Obliged.
Yes. Mr. Naik, you have got the papers? Get me straight to those documents and the endorsements there.
It clearly reflects that the department was aware that the stay order is operating.
Okay, fine.
And in Annexure 15, Lordship, that was communicated to the standing lordship, I mean, the government advocate.
Where is that
Annexure
where is
15.
that endorsement of receipt? Where is your receipt? This is a communication.
Yes,
How can I know that this was served?
that Lordship, only the person concerned, Lordship, that no endorsement was taken, Lordship, no
Why?
receipt was taken.
Why?
But
Why? Why?
it's from the file itself, Lordship.
No. In your file, you may have 101 documents. But how can we come to a conclusion that this document came out from your file to the government.
Then let me take it other way around. Lordship.
Hmm.
So far as this writ petition, Lordship, present writ petition. That is 6148/2012.
Hmm.
In that case, Lordship will find in record that instruction was issued to the concerned advocate, Lordship. And this document 31/10/2013.
Who is there?
I mean, Lordship, on the day of disposal, Lordship, by my Lord Justice Ubria, Lordship.
Hmm.
On that day, same advocate was appearing.
Hmm. No, he can now come forward and say that I have never.
Received. But so far as the other case is concerned, Lordship, instruction was given to her only.
5581 is to one Mr. N. Upadhyaya.
No.
When was that, my Lord Justice?
Instruction was issued to him.
When was my Lord Justice Ujjal Bhaiya's order?
Their Lordship, another advocate appeared, Lordship.
When?
That is 5581.
That order is of
Order dated 13/3/2014. In the second writ petition, Lordship will get that. Annexure 12, Lordship. This is the same letter. In the present writ petition.
There is an endorsement here. But that counsel never appeared.
In the second case, she appeared, Lordship. Lordship will see annexure 12. Lordship will see the name of the advocate. To whom it was issued, Lordship.
Hmm.
And then Lordship.
This is not 5581.
No, that is 6148.
That we are not concerned.
No, 6148/2012.
We are concerned
Instruction
with
was given to her. She appeared. And she
Let her-
was
let her.
aware about the facts of that case, Lordship.
hundreds of cases they do, so we'll give them a leeway. But thing is, this document at Annexure 15,
Lordship.
31/10/2013.
Then in that case, Lordship, I have to search for the issue, I mean, the delivery book.
That is what we wanted here. That is a specific order. You call your director. We'll talk to him. We want these things redressed.
No, Lordship will consider, Lordship. At that point of time, it was 2013, 14, 12.
You have the records with you.
Lordship, even if.
You have
Lordship,
the
even if
records
I
with you.
suppose,
You
Lordship,
have filed an affidavit here recently. So these records should be protected, should be preserved. Because a proceeding
no,
is pending
record
and this is one
record
of the
with me,
issues.
Lord. No, record is with me.
So show me why, when an order was received from this court, why they proceeded.
Lordship, my submission will be the concerned advocate was duly informed.
No, I'm not on that.
Duly furnished.
Your authorities knew that there was an order from this court, wherein the whole process was kept on a hold.
Yes, we are aware about that, Lordship. Two annexure I have placed, Lordship.
I know
Annexure
that.
14 and
I know
annexure
that.
15.
Because you need not be aware through the annexures. You have filed a vacating application.
Yes, Lordship.
So that
No,
was
Lordship, there
rejected.
are other petitions also. She filed one contempt case. That case was also closed. Now, Lordship will
And
also ask
you
why the
filed a
contempt case
review.
was
After
closed.
all those things, you filed a review.
Lordship,
You filed a review.
one review, but the record is not there, Lordship. In the High
The
Court.
order is with me here.
Yes, Lord.
Found the order.
Lordship.
So then also, you did not reconcile these two things. Why? It shows that there was some move to appoint them by you.
Not by me, Lordship, the director at that
Whoever.
point of time, not even the present director.
I'm
So
saying,
that is why
you
I'm saying,
means-
Lordship, if any mistake.
you
was
means
done-
whoever was there.
Lordship, even if any mistake was committed, suppose we have committed some mistake. At that point of time, in the year 2013, 14, Lordship. For that fault, Lordship, can the present director be called for personal appearance or be made?
No,
to-
we want the truth to come out. whether it is the fault of the government advocate who, in
Yes.
spite of being, you file an affidavit, bring it on record.
No,
No, you file an affidavit, 2-page affidavit, saying that these instructions were received by so and so in 5581/2013. However, in spite of that, this was not placed before the court. File an affidavit.
In
We will
record,
ask
it
the
is
Bar
there.
Council
In
to look
record,
at
it is there, Lordship. In subsequent record also, I
File an affidavit.
but Lordship, my submission. will
Can you
be-
file an affidavit to that
but
effect?
My submission will be, Lordship, if Lordship comes to the merit of the case, Lordship.
I'm not going into the merit.
That will be a subsequent issue, Lordship.
No,
If-
this is the main issue.
No,
If the appointments could not have been made because of the interim order and a fraud was played on this court in this connection by not bringing it to the notice, that fact being brought to the notice of this court,
my
what would
submission-
have this court done?
Lordship, my submission.
What
will-
would have this court done? Would have got all the matters amalgamated? Analogously would have heard the matter, then we would have had a result. He would have had no grievance. Now, you have prevented that from happening. You or your counsel, whoever. Both are not different. They are one.
Lordship, my submission will remain, Lordship, annexure for 13, 14 and 15 clearly show that it was, the council was informed, duly informed.
But what
But
did you,
whether
what
any
step did you
receipt-
take?
receipt
Okay,
or
now the
any
second
step-
question.
Lordship.
Now, when you got the order from the court directing for appointing them, there was a clear prescription therein, a recording made by this court, to the extent that the advocate was never furnished with any information.
Yes.
What did you do thereafter? You knew now, before you appointed them, you had the order with you, and therein this was there, which according to you is erroneous, because you had given the,
Yes.
what steps did you take?
That was there for whatever reason.
Whatever reason, no, there has to be a reason assigned to that. Why?
Court says it was not, no instruction was.
I am beyond the court now. I am beyond the court. Certified copy was produced before the authorities. Naturally, they will go through it. We expect them to go through it. There is a paragraph addressed to the fact that the government advocate had made a submission that in spite of writing several communications, she was not furnished with the information. And admittedly, she was not furnished with the information. What did you,
But that is why, Lordship,
on receipt
that
of
is why,
that, what did
Lordship,
you?
We have also asked the department to go through the record of the content case and the review petition. Review was filed by the department itself. That record is not available with me, Lordship. I mean, why?
Mr. Hello, you have
The
the
High
review
Court
petition with you?
website also that-
You are not party.
In the High Court website also, it is not available, but it is.
We have an order.
As disposed of.
We have an order.
So I am looking for that order also. Lord.
Review petition 47 of 2015.
15. Yes.
Etu, paribone anibo kanne?
No, it is not there, Lordship. I have. filed
Review
out the-
petition 47 of 2015. It a corruption.
The record is not available. It's clear, only shows that matter is disposed of. Lordship. Date of
47
disposal,
of 2015, disposed of on 11/5/2015. Yellow night. Auction. Disposed of.
yeah,
I give a file.
it shows as disposal, but order is not there and the date of disposal is also. not
The date of disposal is 11/5/2017. Mr. Chaudhary, you have a copy of that?
Copy of the review application, but the order of person the review.
Review order is with me. Ase rabo yete ase. Nalage. Yes,
That's it.
Mr. Sharma. You were informed on 19/2/24 about the interim directions of this court. Why was this not placed before the?
The document, my lord, was never served upon me. That was my standing. I was not aware of it.
This copy? Yes, show me how this was served on her.
That was my standing.
Find that out
Just
from the.
one line in the order passed in the review petition, Lordship. One
Forget
paragraph,
it.
Lordship.
You forget, we'll come to that. We are not yet in the review order. Find out that copy from your records and show how it was served on.
It is there, Lord.
Now, show me the service. Everything is there in your records. That will not help.
That document I have seen, Lordship. That is why I'm saying.
If you can show that that was served on her, that is the end of the matter.
Lordship, document is there, served or not.
Served,
Lordship,
that is what I want.
confirmed.
How will I draw a conclusion that it was served? Because she will come and say it is never served.
in the affidavit in the review, we have, my lord, stated that I never filed any application. Pursuant to which, my lord, this is supposed,
No, there is an application.
my lord,
The page just before that, that is your application and that is there in their affidavit also.
this one denied in the, my lord, review application in paragraph.
Luna Deka Borua, Nilima Roy Deka.
Lordship, the other candidate I can show, subsequent to furnishing her a copy of that order, Lordship,
Hmm.
she replied, Lordship,
Where?
referring to the order, Lordship.
Sorry.
That is the communication, and next page, your Lordship will see it's a reply from the candidate.
Show this to Mr. Chaudhary.
Sorry to read it. 11/5/2017. তাৰমানে এইখনৰ পৰা এটা ৰিপ্লাই দিয়া আছে, সেই ৰিপ্লাইখন পাব। সেইখনৰ বিষয়ে। এখন 14 হয়, তাৰমানে এইখনৰ পিছতে আমি এটা ৰিপ্লাই এটা দিছিলোঁ। Next page.
And the earlier writ petition was a joint writ petition, 5581.
5581, initially 5581, Lordship.
Joint petition between by respondent number 3 and 4.
Probably Lordship would also like to see the order pass in the content case, Lordship, why it was closed. It was filed by the petitioner.
Right. Because the review petition, the court said,
No,
file a writ
I am
petition.
only referring to the order passed in the review petition, Lordship. One line, Lordship would like to see, Lordship. In the last page, Lordship, in the last but one paragraph. It would be more appropriate to hear the petition, pending writ petition challenging the appropriate appointment of respondent number 1 and 2.
Because that is why I'm telling you, that is because of the paragraph earlier to that.
No, here Lordship has considered that 2% has already been appointed and the court declined to interfere in
It
the.
did not decline.
order.
It said that when the order of the court is already implemented,
Yes, Lord.
there is no question of any review. That is why it said, okay, fine, we hear it. Now the issue is open to
The
us.
court could have at that point of time also interfered
Could
with
have
the appointment. Lord.
not have, that is different, but that
But
will
that
not
is why,
absolve
Lordship,
you.
That is why Lordship.
That
I
will not
submit-
absolve you. No, it's okay. Give it back to him. Give it back to him. Now, Mr. Chaudhary, what do you say on this?
My lord, this is a letter.
Right, wrong, it was brought to your notice why your appointments are not being made.
My lord, in fact, for that, I'll take your worship to the, my lord,
No, this is after that. This is just,
this is.
this
my
is
lord,
before that.
my
Your
lord,
signatures are there.
No, what I'm on is that, my lord, this is supposedly no date is there. But
It's in reply to that next earlier page.
on top of that, my lord, there is a date noted 24 to 2014.
Hmm. And you know, you do one thing, come one step further.
My lord,
There is a handwritten note.
yes, my lord.
That is your letter. It is there in the affidavit now also. It is
Yes.
here in the affidavit.
For that, my lord, this is dated 18 February 2014.
Then
For
that
that, my
reply
lord.
19th.
My lord,
Reply is of 19th.
reply is of 2014, my lord.
No.
This is 2014, my lord. Reply is of 2014.
Ah, 14.
My lord.
That is before the order in 5581/2030. The
No,
order
no.
in 5581 was passed on 13/3/2014,
Yes, my lord.
right? These are communications prior to that.
Yes, my lord.
So on before the last date of hearing therein,
Yes.
you knew why your appointments are not being made.
I did not know, my lord. That is my stand in the review application. My
No, your letter.
Later, my lord, your lordship will suppose that.
Do you dispute that letters?
Yes, my lord. Your lordship will kindly take up my affidavit in the review application.
Then we will go for a examination of that.
Yes, yes, my lord. Your lordship may send it to the, my lord, the FSL also, because there is a clear stand in the affidavit.
What is that?
I'll read that paragraph in the affidavit. Paragraph 8 of the, my lord, the affidavit in opposition filed in the review. That with regard to the statements made in paragraph 43, 42 to 45 of the review petition on the reply, your deponent denies the fact that she has preferred the representation dated 18 to 2014 and that the communication dated 19 to 2014 allegedly marked to her was ever received by her, in addition to denying the fact that there was suppression of fact by her. With regard to the representation dated 18 to 2014, it is stated that the handwriting appearing in the representation is page so and so is not the handwriting of the deponent. It is either maybe a case where a blank signed paper by the deponent has been misused. The deponent.
Why a blank signed paper will come to the
Well, your
authority?
lordship will say this is a courteous paper. How a courteous paper signature is there? Your lordship, my lord, as per the
Courteous
instruction.
paper in your advocate's chamber, you already had a case pending.
Maybe, my lord, maybe, but then, my lord, I will not oppose, my lord, if your lordship sends all this to FSL. Because, my lord, they may be, I do not know, my lord, I cannot say for sure, but they may be manufacturing documents to.
You are replying to which paragraph there, Mr.
42 to 45 of the review application. There is maybe some mistake in the naming of the paragraphs, my lord, but the documents dates are there.
42, 18-2, 43, 8, 19-2.
Maybe those are page numbers. Someone has written your family.
When was this WPC number 5581/2013 filed? Date?
1076/2015.
5581/2013. When was it filed? Sometime in October. October 2013.
2013. 558. 2013. Five five eight one 2013.
Huh?
I think. Five five eight one.
Okay, Mr. Chaudhary, we have got it. We'll get that, no problem.
28th of September 2013.
So after the vacation of the interim directions, the vacation of the IA file,
Rejection of the state.
stay vacating application that was vacated on 12/9. Immediately thereafter on 29, you did not know. Coincidentally, on 29, this case came to the file. Fine. Now, Mr. Chaudhary, as a senior counsel, in such situation, what should this court do? Admittedly, a fraud either by the government advocate or by the department or by you, your client, whoever has been played in suppressing materials before this court. In such situation, what should be the approach of this court?
My lord, so far as the earlier litigations are there, my lord, they have, my lord, reached the quiters.
No,
The-
it is pending.
Review application has been, my lord,
No,
disposed of,
that original
Content-
case wherein that stay is continuing,
my lord.
it is still untouched. It's
My
before
lord,
me today.
In that writ petition, I'm still not a party. I'm not still a party.
No, you need not be.
My lord.
But that order, I'm asking you as an officer of the court, that 6148/2012, that is still holding the field with that interim order continuing till date. Now, in that view of the matter, what should be the approach of this court? Because the order which was procured or which has passed by this court in your writ petition, admittedly, was so done ignoring.
Ignoring the other order.
What would be the effect?
Now, my lord, my submission before your lordship will be, now much water has flown, my lord, under the bridge. 10 years have passed by. And
Will that condone the act?
that is what, my lord, the Honorable Supreme Court has done, my lord. So I'll plead.
Supreme Court 142 power is there.
No, even
For
my
me,
lord-
there is no power of prospective overruling.
My lord, 142, yes, my lord, there are some judgments where, my lord, the High Court said that the appointment was illegal, that was, my lord, pertaining to judges. But the 10 years have passed by, the Honorable Supreme Court has said that, my lord, yes, the High Court was correct in setting aside the termination, but in view of the time lag of 10 years in one case and 6 years in another case, the Supreme Court has said that in spite of that, in exercise of power under Article 142, that has been done, but there are cases, my lord, without, my lord, exercising power under Article 142.
It
that
would
has
be,
been contained.
the Supreme Court exercising that power would always be under 142. That power we don't have. If we
Yes, sir.
hold that an appointment is illegal, it is illegal from the word go. Because that prospective overruling power is also not there to this court under Article 226. We can't say, okay, fine, that was bad, but because of the lapse of time and the developments taking place, we condone that. And we proceed to allow giving it a quietus. Okay, fine, let them continue. But here, the facts as are coming back, the whole recruitment was stalled. That was shielded from this court, forcing this court to proceed in the matter as if a selection was made, appointments were not made. Naturally, rightly, this court passed that order. Any court would have passed that order. But if that aspect of the matter, then it would have resulted in two situations. This court would have not passed this order, or would have tagged the matter with the other case and then had a conjoined reading.
Quite true.
We would have had a result.
I agree to that.
In such situation, I think I have come across a judgment. Not yesterday, I was trying to find that out, wherein the Supreme Court has said that the subsequent judgment is wrong. It could not have been passed because it was passed in ignorance of the earlier. Not exactly the concept of per incuriam, but in such a fact situation. What do you say? Once you can take me out of this, then we can hear the case on merits. Otherwise, this order and your appointment goes. Then we hear it fresh. We take up 6148/2012 for final hearing. But before that, I'll have to consider 1076/2015, your appointment on that point.
My lord, that's why, my lord, I wanted to rely on the Supreme Court judgment,
Please.
which says, my lord.
So nothing more to be said on facts. Facts, we are clear.
Facts, and I am not, my lord,
Mr. Hollow, you also have nothing to say on facts.
On text.
I'll rely on two judgments, my lord.
Hmm.
One is, my lord, 2013, volume 4 SCC, page 690, Rajesh Kumar and others versus State of Bihar. And the other is 2024, volume 3 SCC, page 799. Shivanand C.T. and others versus High Court of Kerala. I have got hard copies, my lord. Your lordship, there is the hard copy. In the 2013 case, that was a recruitment process where, my lord, the answer keys were,
Oh, Rajesh Kumar.
yes, my lord. There I'd like to refer to paragraph 19 and 29. May I read that? The submissions made by Mr. Rao are not without merit. Given the nature of the defect in the answer key, the most natural logical way of correcting the evaluation of the scripts was to correct the key and get the answer script re-evaluated on the basis thereof. There was, in the circumstances, no compelling reason for directing a fresh examination to be held by the commission, especially when there was no allegation about any malpractice, fraud, or corrupt motives that could possibly be vitiate the earlier examination to call for a fresh attempt by all concerned. The process of re-evaluation of the answer scripts with reference to the correct key will be, in addition, be less expensive apart from being quicker. The process would also not give any unfair advantage to any one of the candidates on account of the time lag between the examination earlier held and the one that may have been held pursuant to the direction of the High Court. Suffice it to say that the re-evaluation was and is a better option in the facts and circumstances of the case. Then paragraph 20, that brings us to the submission of Mr. Rao that while re-evaluation is a good option, not only to do justice to those who may have suffered on account of an erroneous key being applied to the process, but also to the writ petitioners. Respondent number 6 to 18 in the matter of allocating them their rightful place in the merit list. Such evaluation need not necessarily result in the ouster of the appellants should they be found fall below the cutoff mark in the merit list. Mr. Rao gave two reasons in support of that submission. Firstly, he contended that the appellants are not responsible for the error committed by the parties in the matter of evaluation of the answer scripts. The position may have been different if the appellants were guilty of any fraud, misrepresentation, or malpractice that would have deprived them of any sympathy from the court or justified their ouster. Secondly, he contended that the appellants have served the state efficiently and without any complaint for nearly 7 years now. And most of them, if not all, may have become overaged for fresh recruitment within the state or outside the state. They have also lost the opportunity to appear in the subsequent examination held in the year 2007. Their ouster from service after their employment on the basis of a properly conducted competitive examination not itself affected by any malpractice or other extraneous consideration or misrepresentation will cause hardship to them and ruin their career and lives. The experience gained by these appellants over the years would also, according to Mr. Rao, go waste, as the state will not have the advantage of using valuable human resource which was found useful in the service of the people of the state of Bihar for a long time. Mr. Rao therefore prayed for a suitable direction that while re-evaluation can determine the interested position of the writ petitioners and the appellants in these appeals, the result of such re-evaluation may not lead to their ouster from service if they fail below the cutoff line. There is considerable merit in the submission of Mr. Rao. It goes without saying that the appellants were innocent parties who have not in any manner contributed to the preparation of the erroneous key or the distorted results. There is no mention of any fraud or malpractice against the appellants who have served the state for nearly 7 years now. In the circumstances, while interested merit position may be relevant for the appellants, the ouster of the latter need not be an inevitable and inexorable consequence of such a re-evaluation. The re-evaluation process may additionally benefit those who have lost the hope of an appointment on the basis of a wrong key applied for evaluating the answer scripts. Such of those candidates as may be ultimately found to be entitled to issue the appointment letters on the basis of their merit shall benefit by such re-evaluation and shall pick up their appointment.
Okay. Now, my lord, this here is a case, there were some aggrieved parties. Aggrieved parties, because my lord, they said that because of the wrong answer script, we are
Somebody
not
got it.
selected. Here, my lord, the petitioner is not an aggrieved party. Firstly, my lord, there was another advertisement. The petitioner belongs to general category. The two posts advertised were for general category and he did not apply. She did not apply. In the same year, my lord. And these are the posts advertised for the reserve category candidates. Therefore, the petitioner could not have been an aggrieved party. In this case, my lord, the person.
Where is that subsequent advertisement?
In my affidavit,
In
In which case?
in 1076.
Affidavit by respondent number 4 or 3?
Both,
Person
in
three, my lord.
both the,
Both affidavits.
in both the affidavits, it's there, my lord, and there is an RTI reply saying that she never applied for this.
Where is that advertisement?
Advertisement, your lordship will
Page
find
10.
at page 10 of the affidavit sworn by Luna Dekaborua.
Okay, let's come to that
There is an
affidavit.
advertisement, after my lord.
Let's
the-
come to that advertisement.
Right.
LDA Junior Assistant.
Yes, ma'am.
This is dated 13/12.
13/12/2012.
Same year,
And the earlier advertisement was of Mr. Haloy,
July.
July.
And the RTI reply, your lordship will find at page 12.
Let's accept that. Now, LDA, 2 posts, right?
Yes, ma'am.
Right? Out of that 2 posts, they say one is likely to be vacant. So only 1 post was vacant. So we proceed with that there was 1 post vacant and 1 post would fall vacant.
2 persons are appointed subsequently. And they were appointed prior to us.
So finish up with your preliminary thing and then we'll go into the merits.
Then RTI reply, your lordship will find.
I got it. I got it.
It did not apply. And the post which was advertised, my lord, although I'm not a man, I'm not a party to that. That is for my lord reserve category candidates. And she is not a reserve category candidate. So therefore, my lord, my submission is that the petitioner is not an aggregate party.
Hmm.
And the other decision also, my lord, I'd like to place
Legitimate expectation.
Shivanand City.
what should the court do that your lordship will find that paragraph for my lord 54? Because that is the query, my lord, came from your lordship's mouth, fell from your lordship, my lord. It was held, my lord, the selection was illegal. Para 54, has your lordship got it, my lord? May I read it? This was selection of district and session judges. And they were continuing for 6 years. Here, my lord, we have continued for more than 10 years now.
Para 55 and 56.
My lord. Perhaps, my lord, that answers your lordship's query, my lord. And these are not under Article 142.
Now, let us go. Mr. Halloy, you want to make your reply against that preliminary thing now, or you want to make it at one go?
I'll make.
Make it at one. Sit down. Now, let us go into the crux of the matter. Even still, your appointments can be interfered with by this court. If I allow 6148/2012, the advertisement will go. If the advertisement can be interfered by this court, then your appointments go.
Yes.
Now you justify how two posts, 100% reservation could have been made as of 13/7/2012. Forget 13/11 to 13/12/2012 because that had not come in. The recruitment process was limited to 2 posts of reserve category candidate. Your case is that there are 6 posts or 5 posts.
I am relying on the affidavit of the my lord.
But
No, ultimately, if you read the affidavit, 5 posts. Because
I'll show you that. 3 posts. Out of that, now you show me how 2 posts in one advertisement could be reserved for the reserve community candidates. First, establish how many number of posts are there in the cadre.
my lord, your lordship has put 2 queries. I'll answer the first query first, my lord. So far as setting aside the advertisement is concerned, if that advertisement is set aside, these 2 respondents in the other writ petition are the only affected parties. No other person will be affected. And we are not party in that writ petition. We could not contest that.
You are there, that it is you are there a party in 1076
Yeah.
wherein your appointments are
Under
in
check.
challenge.
Yes.
So that appointment challenge will have to be understood in the context of that advertisement because there is no other pleading here. Specific to the challenge to only the appointment order, there is no challenge. The challenge to the appointment order is on account of the fact that the advertisement could not have been issued in that manner.
Yes, my
So
lord.
that is covered.
I reply to that will be, my lord, I have not got an opportunity to, my lord, rebut whatever has been stated
Yes,
in the,
you have filed an affidavit to that effect.
in the other writ petition, my lord.
No. In 1076.
1076 is, my lord, where we are parties.
Therein these pleadings are there. These pleadings to the effect that the advertisement is not sustainable is here also.
Look, pleadings in the 2 writ petitions are completely different, fine.
No, in the second writ petition also, there are pleadings. The listed so and so, so and so, so and so. Says that the 4 person, so and so, so and so. Paragraph 10.
Before that, your lordship may kindly come to paragraph 8, my lord. 8 and 10. His case is that, my lord, the petitioner begs to state, paragraph 8 I am reading.
Hmm.
The petitioner begs to state that the cadre strength of LDA junior administrative assistant in the director of workers, government of Assam is 6.
Fine, that is his case.
Yes, that is his case.
You come to para 10, that is relevant.
That the petitioner begs to state that as per the roster adopted by the office memorandum dated 2012-2005, the first vacancy is reserved for STP. Second vacancy is reserved for OBC, MOBC. Third vacancy is reserved for SC.
Hmm.
As per this roster, the fourth, fifth, and sixth vacancies are unreserved. It is pertinent to mention here that already one post of LDA,
Hmm.
junior administrative assistant in the Directorate of Archives, Assam, has been filled up by Bhadraswar Morang belonging to STP category. Hence, none of assistant in the Director of Archives, Assam can be reserved for STP
Hmm.
category.
Hmm.
Now, my lord, his case is that.
Just proceed further.
My lord.
As per the office memorandum, present vacancies are to be filled up by open competition. Apart from it, 100% vacancies in a particular year cannot be reserved. Right?
Yes,
So,
that is the case, my lord.
so that is the only point I have to consider here.
Yes.
Now, you tell me, there is an advertisement against which you applied. 2 posts were advertised. Both the posts were reserved. How? Because the stand of the authorities in all the affidavits, even in that earlier proceeding also, is that we only have 3 posts.
My lord, 3 plus 2 in fact.
Show me.
Government's affidavit sworn by Dharmeshwar Sonomal.
Hmm.
Paragraph. Paragraph 7, last
2011 4 GLT. 11 4 GLT. is all I mentioned.
paragraph 7, last part.
Hmm.
Government.
Paragraph 7.
Paragraph 7, I'll read, my lord. That with regard to the statements in paragraph 89 of the repetition, the deponent some accept the statements born out of records are not true and correct. So in this context, it is pertinent to state that the Director of Archive has only 3 posts of LDA AA initially. Initially 1 post of typist, which was later created by letter number so and so dated 14/11/1979. The post was filled up through direct recruitment on merit basis by one Sri Manik Chandra Rajbangshi OBC. Thereafter, second post was filled through direct recruitment on merit basis by one Sri Sakradhar Deka, General. Government created another post of LDA by letter number such and such dated 12/10/2011. Original creation order number such and such dated 10/8/2010, which is still lying vacant. Thus, the total cadre strength of LDA comes to 3 only by not 6 as has been mentioned by the petitioner. Thereafter, as per the existing cadre strength of the post of LDA in the incumbents joining the directorate since inception of 1990 in the gradation list as on 11/5/2012 is as follows. Manik Chandra Rajbangshi OBC, date of joining so and so, date of retirement 2016. So, my lord, that falls vacant in 2016. Sakradhar Deka, he retired on 31/5/2012. So, as on the date of the selection, this
Date of the advertisement. Stop here. Date of the advertisement that was issued on July 2012. 1 post vacant advertised. The other post that was advertised pertains to Sakradhar Deka. So 2 posts are there at least from 2011 and 1 in 2012. That is it? Okay, now proceed.
in this context, it is further stated herein that the Director of Archive has another ex-cadre post of LDA, come Xerox operator, which was created by order number such and such in 1980. Copy enclosed. This post was initially filled up during August 1981 through direct recruitment on merit basis by one Sri Bhadreswar Morang.
Hmm.
Although Sri Morang belonged to STP category,
Hmm.
primarily research section, scholars and the government.
Hmm.
This is a separate cadre post mainly dealing with the technical works which may be counted as LDA.
Hmm.
Hence, Sri Morang was not appointed as LDA under reserve category as stated by the petition.
So we now have, after paragraph 7, 3 plus 1.
Yes,
1 ex-cadre, 3 cadre.
yes.
Proceed. Now, where are the other 2 posts? We have 3, 4 posts now.
Yes.
So this is the cadre strength, 4 posts.
If I may, this Manik Chandra Rajbangshi, he continued till 2016. So one post he was holding. Now thereafter, my lord, in July and in December, 2 advertisements were issued.
4 posts.
4 posts. Against all
Where?
those 4 posts,
No.
4 persons were appointed,
No.
my lord.
In that second advertisement, it is 2 posts, 1 likely to fall vacant. From where? Yes. From where?
That second advertisement. But so far as the first advertisement is concerned, 3 cadre posts were there. 2 posts were already filled up. 1 was vacant, already vacant. That was as per the roster, it was a SC post. And the person at serial number 1 lordship, it was a direct recruitment. That post was for STP, but a general category, OBC category person was appointed. That is why that post remained back.
So that became backlog.
That became back.
Mr.
That is one.
Nayak, be careful what you are saying. I'll not allow you to go back. When you're making a statement, please be careful.
That is affidavit.
You are going against Article 16(4)(b) in making that statement. Yes, Mr. Chaudhary.
One line I would like to add.
We'll come to you. Yes, Mr. Chaudhary. Be very careful.
It is already in the affidavit.
Then we are going to interfere without any further hearing. That is in violation of Article 16(4)(b).
At that point, Lordship will only consider whether in case of backlog vacancy that 50%.
Mr. Counsel, backlog vacancy would come in and 50% will not come in if the point and the post is carried forward. Here, that posts were already filled up.
Your lordship is right in.
It is not there. That post fell vacant only in
60.
May 2012. So that point only got carried forward. If point is carried forward, even if I hold that one of those posts goes for a particular community, the other posts you cannot add. It will be 100%. Read 16(4)(b). Yes.
My lord, I understand, my lord, your lordship, but the question comes here, my lord. The department may have, my lord, misunderstood what is carrying forward.
That misunderstanding cannot give rise to an illegal
No,
benefit.
but then, my lord, your lordship will also consider a post reserved for, my lord, for reserve category candidate that has been filled up erroneously.
I'm waiting. I've called for that judgment. I'll give you the judgment now only.
My lord, will that post go for all time to come?
So first, let us now come to a conclusion as to the cadre strength as of 2012. As far as you have taken me, that is 4.
From their affidavit, yes, sir.
4.
And there is one ex-cadre, my lord.
No, 3 plus 1. 3 ex-cadre, 3 cadre, 1 ex-cadre, 4.
That is what they say in the affidavit.
4. So 4 posts is what is there. So 2 here and the subsequent 2 from where? There was no vacancy. How did they make that recruitment? Even if I take, now that you have brought the subsequent advertisement also,
Yes.
from where? Excessive.
My lord, that has to be answered by the department.
That Mr.
I
Nayak.
apply pursuant to an advertisement, I get through a regular selection process.
Okay. So your case is that the advertisement is perfect. Reservation as marked therein is perfect.
Even if they, my lord, committed some mistakes, my lord, I cannot be, my lord, dislodged from my service after 10 years.
Thanks. And what do you say about the application of reservation to a cadre strength of 4 or 3? How can reservation be applied when the cadre strength is 3? given the fact that it is 5, 7 and 10. 1997, 10 SSC,
My lord.
PKT worried.
If there is, my lord, plurality of posts, it can be, my lord, by rotation, it can be.
Show me.
That, my lord, on, I rely
Because
on-
I have I'll give you a judgment. Debodotta.
Yes, my lord.
And that judgment was tested in appeal also. And in appeal also it was upheld. And therein, in a cadre of 8 posts, this court has said there cannot be reservation. If there is no reservation, there can be no backlog.
My lord, may I place one judgment on this, my lord? This is, my lord, 2009 AIR SC 618.
Hmm.
My lord, from SCC, I did not go, my lord, download it.
You mean to say that I think it follows PGMIR first judgment. It does not follow the second judgment of PGMIR. Just check up.
PG.
1998 4 SCC 1 is not followed there. The earlier judgment is followed.
My lord, it has followed some earlier judgments. Chakradhar Paswan.
Gone. Chakrada Paswan gone by 1998 4 SCC 1. Chakrada Paswan done away with.
Chakradhar Paswan is 1988 2 SCC.
Then 1998 4 SCC 1. I gave Mr. Sharma that day the judgment. 1998 4 SCC full bench, constitution bench. Mr. This is a 2 judge bench.
This is 2 judgments. No, Altamus Kabir and Markandeya Kajit.
2 judge. What is that citation? 2009.
1 SCC page 1.
Page 1. State of Karnataka versus K. Govindappa.
Yes, my lord. It says, my lord, there cannot be 100% reservation if there is 1 post. There cannot be a reservation. But then, my lord, if there is.
I'm sorry. Uh,
Arati Roy Chaudhary was, my lord, discussed in paragraph 11.
98.
Referring to that constitution bench, my lord. Paragraph 11, I will. If the
You can come to paragraph 24 of that.
paragraph numbers are not telling, my lord.
It starts with the present case falls within the category of a single isolated post within a cadre in respect of where rule of reservation is inapplicable.
In our view. Must start with in our view, my lord.
Just
In our view, the present post
Mhm.
within a cadre in respect whereof the rule of reservation is inapplicable and the said principle has been correctly applied by the High Court in the facts of that case.
As indicated by the High Court.
As indicated by the High Court, each discipline which consists of a single post will have to be dealt with as a separate cadre for the said discipline. And in view of the settled law that there can be no reservation in respect of single post, the appointment with respondent number 1 cannot be faulted. This is particularly so having regard to the fact that the several disciplines are confined to 1 college alone. That is what distinguishes the facts of this case from Arati Roy Chaudhary's case, in which the rule of rotation could be applied on account of the fact that 2 posts of headmisters were available in 2 colleges run by the same management. Moreover, in Dr. Chakradhar Paswan's case, on which the reliance was placed by the High Court, it was noticed that while upholding the rule of rotation of the Constitution bench in Arati Roy Chaudhary's case did not support reservation in a single category.
Fine, no dispute on that.
Yes, madam.
Now you tell me from the reservation policy of the state at that point of time, 2012 and all, it was 5, 7 and 10, 22%. So Now applying, you can't apply separately, you will have to apply individually. 7, 10, and 5, whether one post is made out for any of the reserve communities.
Percentage wise, my lord.
Percentage
My lord,
wise.
that is a
Quota
question.
has to work out.
Yes, my lord.
If a quota does not work out, there cannot be a backlog.
That's true, my lord. That is for the department to answer, and my
No,
submission.
no. Mr. You will have to support that, otherwise you are gone. You are supporting that reservation is perfect.
My lord, my lord, in that event, my lord,
Hmm. Yes, yes, Mr. Yes.
in that event, my lord, the authority have to consider the, my lord, total number of posts, and my lord, that percentage has to be calculated on the basis of the number of
So
posts.
if this court, it is not demonstrated before this court, that that advertisement could not have been issued or could have been issued by reserving both the posts, then I'll have to interfere with the advertisement. Consequences is inconsequential. So
No,
first thing first.
No, my lord, but then, my lord, what the court has to do, my lord, that decision I have placed, my lord.
I know that.
Your lordship will
I know
not
that.
ignore the, my lord.
I know that. But if I have to be satisfied that the appointment were made bona fide at that point of time. If I can come to a conclusion that no, these appointments were made for reasons. Now attaching the subsequent developments in 5581, how the matter was being permitted to be conducted, the judgment coming, how it was dealt with. In that view of the matter, if I come to a conclusion, he is out. He is not getting it. After 10 years, we are not good because he never participated in the recruitment process. So he is not getting anything. The only question is whether your appointments can be saved or not.
My lord, yeah,
He is only an informant now.
he is an informant, my lord, who doesn't have any locus.
He only interest of his is, I made a challenge to an advertisement. If the court says that advertisement was wrong, I'm satisfied. He can't have anything more than that. We will say then further advertisement recruitment would be made. If he is entitled, he gets it. Otherwise, he is out. We are least bothered about it.
No, but then, my lord, my submission is that, my lord, he is not a party aggrieved.
No, he is a party aggrieved with regard to the first advertisement. The challenge made by him with regard to the first.
He cannot be, because, my lord, he is ineligible to participate.
That is it. His challenge is you could not have made 100% reservation. If we hold in support of him, then he becomes a party aggrieved.
My lord, my lord, your lordship will understand, my lord, the petitioner is a set up petitioner, because the petitioner did not participate in the general post also, my lord.
That we will not go into, Mr. Chaudhary. This court is only on the question, two questions. One, the conduct of 5581, that we will decide what to do. Two, this reservation.
True, my lord, but at the same time, your lordship will also, my lord, consider the conduct of the petitioner, because he has not come for asking for any relief as such. He has come to, my lord, to make the water muddy.
No, fine. We have noticed that. That is one point again, which we may go, we'll have to decide against him. That's one point. But now, what is more intriguing is, what is the cadre strength? Appointments are being made, advertisements are being issued. Now, the second advertisement, even if we go by the statements that you have read in paragraph 7, second advertisement could not have been issued.
Last submission will be, my lord, considering everything, my lord. Even Umadevi will come into my lord, rescue, because of the fact that, my lord, there is no interim order on the basis of which I am serving for the last 10 years.
But your appointment is in violation of an interim order.
So it's an irregular appointment, my lord.
That we will see.
If it is an irregular appointment, my lord, Umadevi comes to my rescue, my
That
lord,
we
there
will
is
see.
no interim order protecting us.
That we will see. It's an appreciable argument. It's an argument which should be appreciated. We'll appreciate that. Yes, Mr. Naik. First thing first, what is your cadastre?
If I go by the affidavit Lordship.
I don't want you to go by anything, just give me the actual fact.
So, before that, Lordship, let me honestly submit, Lordship. This file was handed over to me only yesterday night. Officers came to my chamber and handed over the record. So what is as regard the merit of the case, beyond the affidavit, Lordship, I read nothing. So definitely your Lordship.
So
grant me
you
some-
make a phone call, come back at 2. Just ask them what is the cadastre strength of this.
Going by the
LDA?
file, Lordship, cadastre is 3.
How did you make the second advertisement then?
Now that instruction I have.
You have it, we'll have it at 2.
So may I pray, Lordship?
Sorry,
Lordship,
we have heard enough. 2 o'clock.
Lordship,
Only that much information.
Lordship will give me some opportunity to submit on merit also, Lordship.
I'll give you, but first satisfy me on this. First satisfy me that you had posts beyond 4. Because you have recruited 4 persons now.
This is an advertisement of 2012.
Be that as it
Officers are
may.
all new, Lordship.
It doesn't matter.
Even
The
yesterday
cadastre strength
were
they should
unable
know.
To clarify, Lordship, which.
Or you
post is-
call somebody who knows it, I'll interact
No,
with them.
Lordship will grant me some time, Lordship. Even in the last week, Lordship.
No.
Lordship will give me 3-4 days time, Lordship.
No. No need. I just want this information to be clear. Only this. Thereafter, if you want, I'll give you time.
Yesterday, they were telling me that it's 4. 1
4.
is cadre, 3 cadre 4.
So,
That is the stand in the affidavit.
so your stand is that it is 4, not beyond that.
In that case, subsequent advertisement will come into effect.
Then how
From
did you,
post to post.
how did you make that? That means there is a farce somewhere. There is a farce somewhere.
No, let me have that instruction, Lordship. In
I've
writing.
not yet got that pulse.
Lordship, let me have that instruction in writing, Lordship.
Have it. We'll have it tomorrow. Have it. Get your instructions in writing. That as of 31/12/2012
Lordship.
and 31/7/2012, the cadre strength of the post of LDA was so much. Man in position was so much. That much only. Give me that.
Instead of tomorrow, Lordship, may I pray for 27, Lordship? I will get some time, Lordship.
No, it'll be too late.
It's already a matter of 2012.
No. We don't. We have already spent. We have already spent enough.
Lordship will-
24th is the maximum.
First time. we are
24th,
appearing in this
2
matter.
p.m. 24th,
Lordship,
2
earlier government advocate used to.
Mr. Nayak, 24th, 2 p.m.
26, Lordship. It's my humble request, Lordship. 26
2 o'clock today.
to 26.
2 o'clock today.
It will not be possible.
Don't bargain.
And not, I am not relying. I-
Because see, this
What
is
I'm
a
only
very
saying,
serious
Lordship, I
matter.
don't
And
want
I'm
to
taking
rely-
it very seriously, Mr.
Lordship.
Whether it's a government advocate who had played the part or your department director has played a part,
I'm saying.
I don't know.
I'm
But
saying,
somebody had played a part. And this is not called for. This is not called for.
no, I have played
This
the fact.
conduct is not expected, mister. And this is shocking to me also. That said, I've never come across an issue like this.
Lordship.
Suppression was there, but suppression to this extent, I've never seen.
No, I'm not defending that, Lordship. I'm just praying for some time so that I can.
Tuesday.
Get some
First item,
Tuesday, Lordship.
Mr. Hutt, Mr. M.K. Chaudhary, learned senior counsel appearing for the respondents, and Mr. K.M. Laloi, learned counsel appearing for the petitioner at some length. Mr. P. Naik, learned counsel appearing for the state respondent, submits that he 25/6/2024 to bring on record the cadre strength of the post of LDA / junior assistant as of 31/12/2012 and as of 31/7/2037,
Subsequent advertisement.
31/7/2012 and 31/12/2012. Full stop. Mr. Naik shall also bring on record the man in position as of 31/12/2007 and 12/12/2000. No, sorry, 31/7/2012 and 31/12/2012. बाकी वो 31/12/2012 होगा. Full stop. The materials available on record demonstrates that as of 31/12/2012, the recruitments leaving aside the recruitment made in pursuance to 2 advertisements made, there was 1 person already continuing in the cadre of so and so. Accordingly, Mr. Naik, in terms of the affidavit filed by the Director of Archives, wherein it has been contended that in the directorate there were 3 posts, how 5 persons could have come into being in a cadre as of 31/12/2012.
Not.
A list on 25/6/2024 as a parted word. Mr. Chaudhary, kindly go through that B. Datta's case, Puspa Datta, water resources, 2011-4 or 2011-3. That was upheld. And therein it said that 8 cadre posts, you can't have a reservation. And if there is no reservation, there is a clear-cut finding there, you can't have a backlog. And in your case, also that backlog concept will not come in because the post was never carried forward. So kindly address me on that also. And try to work out a way for me to come in your favor. Sympathies are there. But given the fact how it has gone about, not very, because this thing should be stopped. Otherwise, this can go ahead. See the thrust we have. And if that fact is not disclosed to this court, how can this court function? And you get me that, Mr. Naik shall also procure the endorsements of the Office of the Government Advocate, Guwahati High Court, to the receipt of the communications in question.
Subsequent, in the 15.
Pertaining to WPC number 5581/2013, made by the Director, Archives, in the matter. 25th. Pathada. Pathat koi dibe. Ekini khurai di dibe. Yes, Mr. Goswami.
So the sole question is that whether imposition of punishment of censure, whether the period undergoing in suspension can be treated as on duty or not. And whether he will be the person concerned entitled to all this. Look, in this regard, I submit 2 points. One is, Lord, under Rule 40, sub-rule 43, power of suspension is there. And Rule 46, B, that it provides that this censure can be imposed without any DP.
And it can also be imposed after DP.
After
Yes.
this. Now I am relying on judgment of this honorable court, my lord. Reported in lord. This also Meghalaya case, my lord, where discipline and appeal rule is applicable. Assam. If a lordship turn to paragraph A.
Is it the correct proposition?
My lord, we made a research whether this type of judgment available in Supreme Court. Nowadays, Lord, every High Court, in the light of that circular, proceeded that way. Censure they are treated not only a punishment, but for this punishment that
It's a minor penalty. It's a minor penalty.
Minor opinion is not required for.
If you can come to 54B,
My lord,
that is the case.
yes, my lord, that is the my case. Therefore, your lordship. 54B, my lord.
Hmm.
54 is defined, my lord. When a
54B.
B,
B. When a government servant who has been suspended is reinstated or would have been reinstated but for a retirement, so and so, so and so, so and so, pay and allowances, so and so, so and so, so and so. Now come to 3,
3, my lord.
where the authority competent to order reinstatement is of the opinion that suspension was wholly unjustified. The government servant shall, subject to provisions of Subrule 8,
My lord,
be paid the full pay and allowances for which he would have been entitled
my lord.
had he not been suspended. So, it would require a situation wherein you are not blameworthy in any matter.
Yes.
You are not blameworthy in any manner. If that be so, you get full pay.
Now, the
But
other,
censure coming in.
no, my lord, if a person is blameworthy, not blameworthy otherwise, not, then punishment, question of punishment would not come, my lord. In the case, my lord.
No, that is what is being meant here. 3. That means suspension wholly unjustified.
What happened, why I am on that judgment, my lord, in the central government circular, if you read the, that is the 54, it's quoted, my lord,
Where?
paragraph 8
6.
of the judgment, the circular of the central government, wherein central government clarified that the order must be passed or shall be passed under FR 54B. Last portion, my lord. According where departmental proceeding engage a suspended employee for the imposition of minor major penalty finally aimed with the imposition of minor penalty, the suspension can be said to be wholly unjustified. In terms of 54B, an employee concerned should therefore be paid full pay and allowances for the said period by passing a suitable under FR 54B.
Mr. Kotoki, what was the finally the penalty imposed is page 48, running page, Annex B.
In my case, my lord,
Hmm.
it's a minor penalty censure.
That resolution of the board, where is the penalty order?
Penalty order at page 31, my lord. Third paragraph, my lord. Yeah, nothing up to your lordship, my lord.
So your grievance is only with regard to this penultimate paragraph.
Yeah,
That subsistence allowance as before.
that's fine. If your lordship want to see the circular of central government, I have the copy.
No, it's okay. Yes, Mr. Goswami.
Lordship,
What is your stand?
Lordship, rule 46A,
Hmm.
sub-rule 1, censor or warning.
Hmm.
Censor, it is treated as the penalties.
Hmm.
And therefore, the board of directors rightly resolve this resolution that to censor and resolution number 2B, be it resolved not to interfere with the earlier decision of the board adopted by resolution number so and so. So, in my affidavit, Lordship, page 7 in my affidavit, Lordship, is that a resolution, Lordship?
Now,
Lordship,
one thing,
Lordship.
if you come to that second resolution,
Yes, second resolution.
first is okay.
Yes. 2B.
Huh. Now, come back to the High Court order. Come to page 25, para 18.
Yes, Lordship.
The above aspect coupled with the fact that
Yes.
they have properly inspected so-and-so is found guilty as per so-and-so, taking into account so-and-so, declared that the interference with it is called for. Accordingly, the demotion of the petitioner from grade A. So, whatever decisions you took
Yes.
leading to the quashing, or leading to the imposition of the penalty of demotion, plus the other factors, everything quashed. So that quashing will also mean that those decision of yours also gone. Now you are imposing, then the court said, gave you a liberty
Yes.
with regard to charge
Also-
number 1.
Fresh decision for imposing any lesser punishment as
Envisaged under Article
46A.
A.
It means
Now-
46A lesser is 1.
Forget it. I accept that.
Yes.
Now, it would require a fresh decision as to whether while putting the new penalty in 2. Earlier it was 2. Now 2 is gone.
Yes.
Earlier it was 1 and 2. Now 2 is gone. So how can you go back to your decision, reiterate your decision of 8-4?
In paragraph 20, my lord, court directed them to consider that aspect of him. Paragraph 20 of the
As
judgment, my
to
lord.
how the period during the petitioner
Paragraph
remained
20 of
under
the
suspension
page
is
26, my lord.
as the pro-
So this is wrong.
No, Lordship, that be it resolved.
Say you said there was a elephant. Elephant. But subsequently it turned out to a small mole. Now the house you build for a elephant will not suffice will not be too much for a mole. You will have to now take a fresh decision. We'll interfere with this. We are remanding back the matter to you. Within 1 month, take a fresh call. Mr. Kotoki, we'll remand it. Because I'm not very sanguine with this. Because 54B, there are judgments today I'm not carrying.
Then there was. When
There are judgments which says-
Supreme Court censored the punishment.
No, censure is a penalty.
Yes.
Penalty.
Penalty, and in our state, as per the rules, there is a government notification of 87, which says if you are under seal cover, pending departmental proceedings, subsequently your case for promotion is considered, and you are found eligible or what, it is kept in seal cover, and the disciplinary proceeding goes on. Say after 6 months that disciplinary proceeding is over, imposition of penalty of censure, that promotion goes. Get my point?
Yes, yes.
But the beauty is, it says that, say, you are imposed with the penalty of censure on 1/1/24, and the DPC is meeting on 2/2/24. Then your case is to be considered. 87 notification is there, 1987 notification. And with regard to withholding, it says till the currency you cannot. Say 2 increments, 2 years. For that 2 years, you will not be entitled to consider. So what we do is we interfere with this penalty, send it back to you. We give you a month's time from the date certificate. You place this judgment before them. Place this judgment before them. A representation and a certified copy of this order. 1 month, board will take a call in terms of the earlier directions of this. Dispose of. Dispose of.
My lord, this matter may be passed for the time being.
Let it be taken after vacation, and it's a regarding the appointment of Safai Karmi in GNC, that is in 2015. Now the situation has changed.
What is the change?
Everything has become, almost everything has become mechanized now. On trains and all that.
They are still working with you.
No, they are
You're
not
still working.
And,
No, they are not working. They want there should be a Safai Karmi for the ladies also.
Who is on legs? Who is on legs?
in court number.
Who? What is the name?
Yes, it.
Let's circle. We'll see. Correct. Mr. Soikia. Go through this. Hmm. The husband of the petitioner was an CRPF constable. He was killed in an Naxal attack. He was paid with the benefits. Under
this scheme.
No, he was paid, the central government, whatever is there, was paid to him. But the state is to release 5 lakhs.
5 lakhs.
That is the, that is stated to be the position. Naxal attack, so and so, he is a resident of Morrigaon. Now, this, right? Matter to so and so financial that does not fall under the scheme expression. Just check up if it is covered by your scheme, then we will direct whether somebody is appearing or not, we will direct. If you tell me that this is not covered, there is 2 affidavits. Go through the affidavit of the Assistant Inspector General. It's a green flag. Go through it, tell me, and if you find that there is some money due, we will direct, otherwise we will dismiss it 40-40. Okay. Time it.
So, madam, there are sometimes message. He'll be
there the whole day today.
My lord, this is a very old pending matter, my lord. Several times it's been taken up. So today, my lordship was pleased to fix for hearing and disposal. My lord.
You are still in service, Mr.
Yes, my lord, I am still in service, even, my lord, under the 2017
Give me a provincialization order.
No, my lord, I have not been provincialized. That is my case.
No, the provincialization order of the
School,
School.
college, my lord.
Hmm.
Yes. Lord, the provincialization order, my lord, may be pleased to find. Lord, the page 28, my lord. Sanction of creation of post. Then, my lord, is at page 34, annexure 6, my lord. 20th of January 2014. My lord, all the staffs were provincialized, excluding me as the principal, my lord.
Why? What was the
Yes,
reason?
my lord, the stand they have taken that, my lord, on the day of provincialization, I did not complete the minimum requirement of 15 years of service, which is required as per the UGC regulation, my lord, relevant at that.
Then why was your case not considered under the 2017
My
Act?
lord, they have considered my case.
2017,
Yes, my lord,
what happened?
as a tutor principal, but that is also kept in abeyance, my lord.
Why?
My lord, the court has already passed several orders, my lord.
Where is that order?
My lord,
Tutor
in the present petition also, my lord.
Where? No, 2017 Act,
My
tutor principal, where is that order?
But that is in subsequent record, my lord, but it is also reflected in the order sheet of this.
So
proceeding.
2011, that prayer of yours here cannot be considered because that is gone.
No, my lord, my lord, this honorable court has, my lord, said me that that is a, my lord, plea taken at that relevant period of time when the act was surviving.
No, because you are not considered under that Act.
No, my lord, the case when I filed, my lord.
Then we have tens and thousands of cases like that pending.
No, my lord, there is an order of this honorable court also, my lord.
Where?
My lord, what I am submitting, my lord, that when the act was surviving by operation of law, my service.
Dilip Das.
Dilip Das and several judgments
That-
have been passed. my lord.
In that case, there was a finality attached. The orders ministerial act had not taken place. That is why this court said, okay, 2011 will come in.
No,
In
my
your
lord,
case, it's a case of non-consideration,
So my case was considered, my lord.
where
My case
post-sanctioned by the government.
Yes, my lord.
show me the-
Process has also been sanctioned, my lord.
Show me that.
Yes, my lord.
Where was your case dropped?
My lord, may I kindly turn to page 20. My lord can peruse page 26, annexure 4. Eligibility of post and person eligible for provincialization. of
Page?
service. 26, annexure 4, I am referring, my lord.
What is this? Who issued this
My
director?
lord, this is
This
the
is not-
direct.
Where is the such list from the government?
No, my lord, my lord, may I kindly turn to the next page,
Hmm.
that is of 4th January 2014. Deputy Secretary to the Government of Assam,
Hmm.
addressed to the Principal Accountant General Assam, and
Hmm.
wherein, my lord, the principal post has also been sanctioned.
Hmm.
At page,
That is in general.
no, my lord, that is in general, and in that general also I had been included, my lord.
No, you have not been included because it is the stand of the government before this court that
No, no,
on
no,
the date.
After everything is over, when in the provincialization order, my lord, my name was not included. Then after filing of the petition, they have come up with an affidavit, my lord, saying that as I could not complete 15 years of service, my lord, that's why I cannot be considered. Now,
No,
my lord,
not considered.
appreciate, my lord, kindly
the
appreciate.
word is was not considered.
Was not considered, not, my lord. Their view taken that my provincialization was.
As such,
My lord.
services of the petitioner could not be provincialized as principal.
No, my lord, it is
Now tell me,
My
in
lord.
2017 Act,
my lord.
your case was considered.
My case was considered.
Where is that order?
My lord, that order, my lord, my learned friend, Mr. K. Gogoi placed once, my lord, but it has not brought on record by an affidavit or any
No,
other.
he plays, you don't have an access to that copy.
No, my lord, because it has not been provided to me, my lord. But I have been subjected under the 2017 Act, and, my lord, as a tutor principal, they have considered. Now, my lord, my case in this petition is that, my lord, all together, there were, my lord, several principals were provincialized. None of them were qualified and eligible to be considered under the 2011 Act as per the UGC regulation. By relaxing the provisions, my lord, they have provincialized all those persons, excluding me. What was my fault, my lord? I have been targeted singly in the entire state, my lord. That is a clear case of discrimination, my lord.
Okay, we'll have it next week.
My lord.
Mr. Gogoi, you continue with your matter, we will have it next week. As agreed to by the parties, raised it to list this matter again on 25.
My lord.
Mr. Gogoi, one thing, his case under 2017 also not considered.
Not here because.
15 years, same plea.
2007. Not my instruction was that it has been considered. my lord.
No, it is tutor, as a tutor
Yeah,
principal.
the tutor.
Was he given that?
No, as a tutor principal.
Given?
That name, my friend can brought the same on record.
You are not even a tutor principal today.
No, my lord.
Why?
As
No
a,
benefit.
as a tutor principal also, proposal was there also.
You can take it to its logical conclusion, give him what he gets.
Possible.
Huh? From the date you bring that, I'll dispose it of. Get me that order.
Obliged.
Or the proposal before the SLC, whatever is there, get it, we will ask it. And he will be given the benefits from the date persons under the 2017 Act. That is from 1/1/2021.
No.
Give him that benefit, he gets something,
No, sir.
right?
Obliged.
Lordship, appearing on behalf of MP Sutri,
Hmm.
kindly adjourn the matter for the day. He's busy for bar election now.
Hmm?
Busy for bar election.
Oh, ho, ho, ho.
Adjourn for the day.
Election.
As prayed for by the Learned Council for the parties, list this matter again after the ensuing vacations on when this matter has to be heard early. MPhil already, I was under the expectation Mr. Chaudhary would come and he will give me a new light into it. Otherwise, Order is ready.
Lordship
Om Prakash.
Lordship has decided an exactly similar line recently Punjab and Haryana High Court, even Karnataka High Court and Rajasthan High Court, I will place it. Exactly Lordship's line.
Now we can't disturb him next week also.
Lordship.
So
After
let us
swearing
have it on
But we'll fix it after swearing ceremony.
18th
18th of July.
July.
Lordship next week.
Next week?
Next week. 18 next week. Lordship.
You want it, sorry, 25th,
Lordship.
25th.
Lordship.
25th, 7.
Obliged, Lordship.
This was going to
Here, here the affidavit is ready. There's some minor corrections, but during the course of the day, we will find it.
Mr. B. Gogoi, Learned Counsel for the petitioners, for the respondents. State respondents submit that the affidavit would be filed during the course of the day as undertaken by him earlier, during the course of the day.
Yes.
Accordingly, registry to list this matter again after the vacations on a date to be fixed by. God bless.
Your Lordship, kindly see order dated 4/6/2024. SC BTC was asked to take instructions.
Get hold of Mr. Bora.
In this case, my instruction is evident, madam. It may take up next week.
On the last day, my friend was directed to verify whether Pune after judgment is covered or not.
Next week, madam, any date, madam.
Tomorrow.
Madam.
Over next week. 24 matter, right? Next week. As pray for by Ms. S. Chutia, Learned Counsel for the petitioner, for the state respondents, who prays that she be given a week's time to complete her instructions in the matter. Prayer accepted. Registry to list this matter again on 27th. You have an order with 2 days delay, you will get it.
God bless you.
May I pray this matter will take it up after some time. I'm late by say admit to 2 o'clock.
Mr. Gogoi, you have got your instructions.
Yes, madam.
What?
Madam, their contention is that, madam, so far as the university part is concerned, it is a government who has taken that policy decision, that notification, madam, where they have been entrusted with the responsibility of conducting the exam.
You satisfy me on one thing, whether this institution is under you or as to Assam state,
Ours.
yours.
Lordship, we are now
They
independent.
are a university, madam.
I'm independent.
No, that institution of yours, that Girijananda,
That is our constituent.
no.
No. It's
Your,
asked to.
go through your pleadings. It seems that it is under Astu, not
Yes,
under
Earlier it was us to
but that conversion is not there.
Lordship.
You see that.
Lordship.
Two, there will be difficulty, madam. There is a special division bench, madam. There is a series of.
No. You go ahead with your selections. We are not very. But if they are a university and they'll have to satisfy me that this is under them. If it is under them, in terms of the act, your own act, you have created that. Now you can't subject a university to another university, can you?
In fact, my lord, so far as my lord,
No. Can you subject
for engineering course, my lord?
that all the things are under you?
No. In case of BE, my lord, there are private institutions is there, my lord. In Girijananda, my lord, they have their own engineering college.
Whether it is affiliated to Girijananda or
Astu is
Astu.
conducting the exam, my lord, so far as the entrance examination is
fine. Whether the engineering college is under them or Astu,
that I will have.
you have that instruction also.
What happened? Our university was enacted last year. Lordship. After enactment of the Private University Act, all the performance.
No, that you will have to, because you have made categorical statement in one of those paragraphs that it continues under Astu till date. You see, if that be so, we are not coming in your favor.
Lordship, that's what I'm checking.
We are not coming in your favor. You will have to satisfy that. When? Today?
Today, Lordship, let me check.
Before 1?
Before 1.
Yes.
Before.
Yes, please, Your Lordship.
Given? Huh.
My lord, I have taken instruction, my lord, he is ready to face the inquiry, my lord, because, my lord, actually, my lord, he was on that, he was a guardian, my lord, that is why he was selected, my lord. Otherwise,
So it is that record which Mr. Chisti has,
it can be edited also, my lord,
huh?
as per my instruction, my lord, by the concerned authority, by the headmaster.
How can you? Portal you cannot.
Court. My lord, it can be edited, my lord,
It cannot be.
but that should be incorrect, my lord. He
Why?
is ready to face the
Why?
trial.
We'll accept that and we'll say you don't have a case.
My lord, my lord, kindly, my lord.
You go upon it.
Regarding that, my lord, whether it can be edited or not, that instruction
See,
will be taken. my
a
lord.
small girl is involved,
Yes.
a minor girl is involved. Second time, I am excusing. There was another similar situation arose. If I do it, that girl would get bad publicity. 7, 8 years old girl, I don't want that to happen. But the materials that are there, I am sure, forget your political dreams on the back of your girl. Don't project your daughter in this manner.
That was not actually my.
That is what is done.
Yes, sir.
That was.
That is what is being done. Mr. Counsel, sorry. Will not support this. I'm passing my order. You take it. Anything more, Mr.?
No, yes,
We are dismissing.
yes, sir.
You want to say anything more?
But regarding my lord, date of my lord. admission-
Okay, tell me.
No, no, my
Okay,
lord.
okay,
I'm sorry, my
okay,
lord.
okay,
But-
fine. Now you are arguing.
No, no,
Let us
my lord,
argue.
I am not arguing, my lord.
Let
but
us deliberate.
regarding, my lord,
Deliberation.
Date of admission, my lord.
Okay, what is the date of admission according to you?
My lord, 1/9.
1/9. When was the
1/8, my lord.
1/8? When did the academic session begin? When did the academic session begin?
Actually, my 23, 24, my lord.
23, 24. It does not begin in August. Does it begin in August? Or in April? Or in January? When?
January.
Now tell me.
January.
January. August, you bring your daughter here. When was the SMCC meeting held? Constitution?
8/11.
8/11. Now tell me, why did you bring your daughter in midst of her mid-academic career? Why was she brought? If not for becoming a president of the body. What was the reason? Show me the reason. There is to be some reason for your daughter's transfer. What is that reason?
Actually, my lord, he was in private school.
Be that as it
Yes,
may,
that is primary-
be that as it may, why
Financial-
a week before the elections, such things came to your head? Because otherwise you will not be able to become a president. Now to become a president, you have used your daughter. Right? Very bad. At least for this good. You may not take it in a, but this is not done. Using a small minor kid for advancing your political will. Now tell me, what is your legal right to be the president? Tell me.
Legal right, my lord, because.
What is your legal right?
I have come, my lord, against my lord, an order passed by my lord DO, my lord.
No,
Government office.
I want your legal right. If I don't allow you to be the
Because
president,
I was-
no, what legal right of yours is being, or fundamental right of yours is,
Article 14, my lord.
where? Show me how Article 14 comes in. Show me. We are taking it up. Show me. Now it will be cost. Exemplary cost. And it will not be nothing less than 5 lakhs now. Okay. Tell me. Argue.
Another.
You want a date for argument? Want a
But I
date
am
for
not
argument?
my lord. But
Mr. Counsel, do you want a date for argument? Want a date? Take a date. I'll give you a date. But now you will have to show me your right. And I'm telling you, if you can't satisfy me, it is 5 lakhs. This court, in my court, I'm not going to be here. I'm not going to. Tell me, when should I fix this matter?
not required.
No, it will be
Your
required.
lordship may dispose.
No, I'll not dispose it of. I'll not hear you. Tell me, when? Tomorrow? Monday? Tuesday? When? Tell me, give me a date. I'll give you an opportunity. I'll write now the order that I'm giving you opportunity to make argument with regard to this. Tell me. Coming to a writ court with these facts, such petitioners We will not be with them. Tell me. No, I'll go. Enquiry, you have asked for an inquiry also. We'll do that also. We will do everything now. When? Tomorrow? Day after? You tell me.
It can be disposed of.
No, it will not be disposed. Mr. What is your name?
S.H. Sigdal.
SS?
S.H. Sigdal.
S.H. Sigdar, learned counsel for the petitioner, disputes the instructions as placed on record by Mr. SMT Sisti and contends that the portal has been manipulated by the vested interest, including the respondents hearing. And therefore, the admission date as shown therein as 9/11/2023 is so done on manipulation effected in the said portal. Right? Mr. Sigdar further submits that in the denial to him of the post of headmaster, his fundamental rights have been violated. Full stop. On being queried as to the nature of the fundamental right that is now violated, Mr. Sigdar has submitted that he be given a date to make his submissions in the matter. Full stop. Given the nature of the dispute raised and the conduct of the petitioner coming to the forefront, this court would also like to bring on record that this is a fit case wherein exemplary cost on the petitioner is called upon to be issued. However, the same would be considered on the next date upon hearing the learned counsel for the petitioner on the right he claims to have been violated by the respondents in the matter. Full stop. As a allegation of manipulation of the portal has been raised, Mr. S. Bora, learned standing counsel, Sarva Shiksha Abhiyan, is requested to receive instructions from the executive director, Samagra Shiksha Assam, as to whether such manipulation of the portal is permissible.
Yes.
Also, such information be taken in writing and placed before this court on the next date of listing. List this matter again on 26/6/24. And if I don't find you here on that day, I'll ask the Commissioner of Police to pick you up, petitioner, and bring him here at 2 o'clock. Let us stop this business of using kids for advancing political purposes in schools. Last time, it was a very minor child.
Yes.
It was around 4 or 5 years. Your child is a bit grown up now. Maybe we can take a chance with the petitioner, father. Next day. And again, Mr. Counsel, no argument, no adjournment. And if I find no representation, I assure you, your petitioner will be arrested and brought here. There is a limit, Mr. Sisti.
Yes.
Yes, Mr. Fukan was supposed to. Oh, at 2 p.m. 2 p.m. It's 2 p.m. Duta Bazaar.
My lord, to perform Eid, my lord, I was at Karimganj. Today morning I reached at Guwahati, my lord. Kindly any other date, my lord. Tomorrow or day after tomorrow.
Mr. Counsel, this court is sitting here, but you should have the courtesy of informing the learned senior counsel who appears that you are not in a position to do the matter today. He will accommodate you. But courtesy demands that at least to his junior, you should have made a call. Right?
Let it be fixed for hearing any other day.
Whenever you want it.
Ready, man.
When you
Very
want it.
interesting point is there.
Huh.
The person who was terminated at that period of time, only one question. I'm challenging, let it come after vacation. The Lordship will fix it.
You are appearing for respondent number?
8, my lord.
as prayed for by the learned counsel for the respondent number 8, that on account of certain personal inconvenience, he is not in a position to argue the matter today. So, Mr. B.D. Das, learned senior counsel appearing for the petitioner, does not object to the said prayer and accordingly, but however, submits that given the nature of the issue, dispute raised in the proceeding, an early resolution of the same is called for, and accordingly, prays that the man accordingly requests that the matter be listed for final disposal on a date after the ensuing vacations. Accordingly, as agreed to by the learned counsel for the parties, registry to list this matter again on 18/7/2024.
Published.
This matter, Lordship, respondent has filed their affidavit, Lordship. We need some time to file our reply, Lordship.
Mr.
Thank you.
N.K. Sharma, learned counsel appearing for the petitioner, submits that he be given 2 weeks' time to bring on record a rejoinder to the affidavit filed in the matter by the respondents number 4, by the respondent number 6. Prayer accepted. Registry to list this matter after 3 weeks.
Lord, matter pertains to my lord, bring for proportionate pension matter. In this regard, my lord.
Hmm.
Respondent number 4 and 5 have filed their affidavit.
Lordship, Lordship, in this matter, due to lapse on our part, Lordship, we need to communicate with the department, Lordship. So, Lordship, may I pray that at least maybe after vacation, Mr.
After that prayer, what can I do? Mr. A.R. Tabilda, learned counsel appearing for the respondents number 1, 2, and 3. Submits that he be given further 2 weeks' time. 3 weeks' time.
After vacation, Lordship.
3 weeks' time to bring on record the stand of the set of the respondents by way of filing an affidavit.
Lordship.
So, prayer accepted. List this matter again after 3 weeks on a date to be fixed by the registry. Also, it is expected that by the returnable date, before the returnable date, the state respondents shall bring their stand on record by way of filing an affidavit.
Lordship. Obliged.
In this case, Lordship, we are led by Mr. D. Das.
There was a serious objection from the
Yes,
petitioner.
but there is some
So we are hearing the matter. Start.
There's some miscommunication.
No, there was a serious objection made.
Yes, the case, the senior counsel case,
Mr. Chaudhary's name was never taken, but it was said that they had never consented to the
Yes, like-
adjournment. So you are there now argue.
he will argue, let's say. Because
You argue. Because morning a prayer was made, it was objected to.
Yes.
So now you will have to argue.
he has been engaged, let's say, the petitioner has.
I don't know who is arguing. But my question is, in the morning when a prayer for adjournment was made, it was seriously objected. So that means what? Matter should be taken up. It is being taken up.
It may be taken up at 2 p.m.
No, we have fixed other matters at 2 p.m.
I have not gone through this since he has been engaged, let's say. His case is very low. After some time.
Don't just object for the fun of objection, right? I kept it because there was an objection made on behalf of Mr. Das. Sorry, prayer made on behalf of Mr. Das that he is out of station with this stipulation that the consent of the petitioners was taken. But still a counsel for the petitioner came up and objected. Right? So I keeping it for some time, you come and argue the matter. We are hearing it. We'll hear Mr. Das on Monday. We'll complete your part today. Next. Mr. Chetri, Monday Mr. Das can argue? Monday or Tuesday? We'll fix it, but we'll hear. When there is an objection, we will not permit.
Maybe. May I please, Your Lordship? 35.
Hmm.
The issue is very small, but resolution number 5, we have failed to take state, Lordship, though there is orders. So if Lordship allows us once again to take steps, to take it by today or maybe maximum tomorrow, Lordship. That is the university which is resolution number 5. We failed to take the steps, Lordship. And otherwise, Lordship has heard once, but again, it got listed in Lazima code, so there is an order of Lazima.
Mr. Kolita is appearing for the Global University
No, I
You're
have only
not-
for response 6.
or 6.
We'll just take them after the vacancy, they will list it, Lordship, because that there is an order. of-
Now show me
Yes.
how this Global University will have jurisdiction in.
Lordship, we have, the petitioner being from the Assam, he took the course from the Nagaland University, appeared in exam and every
Oh.
admission.
Then you will have to show me that you completed the course there and you took leave here.
Lordship, the distance learning,
It cannot be. It does not have jurisdiction here.
but Lordship, what,
Supreme Court decisions, you know,
Lordship, yes, Lordship.
after that also. How will that Nagaland University have jurisdiction here?
No.
Then where is your right? Forget, let them be comfortable there. Without them also we can hear this matter.
Lordship, that is correct.
So now you make your submission, satisfy me.
Uh.
I don't understand this. I only want a clarification that Global University, you are in Nalbari,
Yes, Lordship.
Global University that has extended its jurisdiction till Nalbari. Show me that. I'll allow your writ petition.
Lordship takes it after vacation, we'll come back on, only on that point.
No, last date also I stopped on this only.
Lordship.
Mr. Hazarika came. Today you came.
Lordship,
Boa, now today both of them are there. So in the second half, we'll hear it.
yes, Lordship.
Indeed, the instruction,
Only with regard to Lordship, how,
and our instruction is very clear, Lordship.
yes, Lordship.
So we'll have it in the second half
Yes, I'll-
and
only, we'll address only to that point.
only on that point.
Yes.
Yes, you don't seem to be very happy.
No. My happiness makes no sense.
এই তো বাকি দিব এটা মোশন থাকি মোশন দিব
May I please? My lord, in this case, the petitioners are the, my lord, the graduate teachers of the special schools of the government of Assam under the Department of Social Justice. And they are regulated by the impugned, my lord, the service order. Assam.
This has to be now finally heard and finished off.
Yes, sir. Your lordship can dispose it.
Today, not possible. List this, as agreed to by the parties, list this matter again on 23/7/2024 and endeavor would be made to dispose of the matter on that day. Yes, Mr. Chaudhary, your junior had very serious objection in giving an adjournment in the matter.
Oh, my lord,
Morning.
Oh, sorry, actually, I was in legs in court.
I'm not on that. Today morning, on behalf of Mr. D. Das, an adjournment prayer was made.
Yes.
And your junior had a serious objection. And when the matter was taken up, I said, you had a serious objection, now you argue.
We are not there.
When do you want it? After vacations.
After vacation.
Hey, লিখি দিব।
My lord, give a date, not on the first 2 days, there are.
এই, কিমান আছিল item?
Additional
22?
affidavit. There is some additional affidavit.
28 to 31. Huh? 28 to 31. As agreed to by the learned council for the parties, list this matter again on 23/7/2024.
23, my lord.
23.
Yes.
I only kept it because he had so serious objection. I thought there is something you want to.
The thing is, my lord, these people, they come every day. In fact, my lord, we had accommodated
No.
Mr. Das on so many
No,
occasions. because-
Mr. Chaudhary, why I deliberately did it was because the submission that was made in the morning 10:30 on Mr. behalf of Das, that this was with the consent of the petitioner.
No,
This
because
was the
actually
argument made.
Yesterday, I think they sought consent. Anyway,
If Lordship may convene It cannot be taken on 25th of July.
Mr. Da Chaudhary would take at least a day.
All of time like that.
He'll take some time to argue this. It's
Yes.
not a matter of 5 minutes, 10 minutes.
Yes. Obviously.
It.
Your worship, may have seen paragraph 8, my lord.
8, yes.
Paragraph 8, my lord, we have stated.
Till date.
Yes, my lord. Now.
So if you are under Astu, why should you be given?
True. I'll, may I take your lordship to my lord, page 40.
Page 40.
40, my lord. Page 40.
This is the act.
Yes.
Now, where is that order or communication or something
Well.
to show from Astu you came to this Girijananda Chaudhary University?
In fact, if your lordship kindly comes to the previous page at page 39.
Huh.
39 shows, my lord, that is a, my lord, affiliation for.
This is the institution,
Yes, my lord.
Girijananda Chaudhary Institute of Pharmaceutical
Yes, my lord.
Science.
Yes.
This was with Astu.
Yes, my lord.
So you say till date it is with Astu.
Yes.
So if it is with Astu,
It is not, my lord, because,
that is what I am not finding, Mr. Chaudhary.
my lord, page 40, my lord, if we act, my lord, thereafter.
You have come in, no problem.
We are no longer an institute, my lord, we are in university.
You have become an institute. But this Girijananda Institute,
Yes, my lord.
what is it called? Girijananda Chaudhary Institute of Pharmaceutical Science has not become a university.
That has not.
It's a constituent.
Yes.
Now show me after, because your statement is till date, you are under Astu.
Now, my lord, your lordship, can you come to page 53, my lord?
50?
53, 53. 53, that is a, my lord, Pharmacy Council of India's, my lord, communication. That is,
And you see, controller exam, Assam Science and Technology University, affiliation body.
that was for, my lord, 22, 23. Thereafter, my lord, new document has come, my lord, showing that.
Without that, how can this writ petition, your claims here be considered? We cannot.
That is there, my lord, we can send it by mail.
Because at least something I should have.
Yeah.
Because now your case is, I'm a private university, this is my constituent.
There, my lord, it has been, this has been shifted, my lord.
So that is not, because here till date, para 8,
That is the one of the.
last time we missed this. Because same, maybe it's with the pharmacy college also, it's the same thing. Same, this one only. If it is under Astu, that exit examination also you may not have been.
That's another.
This was not pointed out to this court,
This was not, my lord, placed before your lord.
right? And we went with the belief that you are a constituent under Girijananda University.
That is correct, my lord. Only
But
one-
that is
one
not there
document-
on record.
One document.
You can get that on, get to me. File an additional affidavit by tomorrow. We'll have it tomorrow.
No, my lord.
Because without that, I can't come to yours. I can't come to you.
True.
On the prayer made by Mr. S. Chakraborty, learned counsel, appearing for the petitioner, who submits that an additional affidavit would be called for in the matter on behalf of the petitioner University, comma. The matter has been requested to be listed again tomorrow. The same is not objected to by Mr. B. Gugui, learned standing counsel, Health and Family Welfare Department. So accordingly, list this matter again tomorrow. By slip koi dibo. File na lage, file to apna tak thoi dibo, session.
Highly obliged.
Just get that, otherwise we will not be in a
Your
position.
worship is right, my lord.
We will not be, we
And it
can't.
was hurriedly filed and that's why you put it on that.
And that statement till date, 2 words.
Not that towards.
And this did not come to my knowledge in that exit examination. Otherwise, that would also you would not have got.
Obliged.
Lordship, here in this matter, Mr. K. Gugoi appears. Lordship.
35.
Today, he has.
Mr. Sharma, a special request was made by Mr. Gugoi today that there is a
Special bench.
special bench constituted. Day-to-day hearing is going on with regard to the challenge to that Act 2011. Unfortunately,
I can finish my part, Lord. You will take note.
but God knows when he'll come, he'll argue. Together, I like it. We'll have it on Monday,
Can it
Tuesday.
Tuesday?
Tuesday. Okay. As agreed to by the parties, registry to list this matter again on Tuesday. Full stop. Mr. Sharma, S. Sharma, Learned Senior Counsel, has expressed urgency in the proceedings, urgency in the matter. And accordingly, an endeavor would be made to dispose of the same on the next date of list. Fine.
Highly obliged.
Interim orders passed earlier to continue until further orders. Daily, that prayer from a senior advocate does not miss.
Let's see the last.
Yes, sir.
Well, let the turn to your lordship's earlier direction. An affidavit has been filed
Hmm.
by the respondents.
Hmm.
Where now they have come up saying lordship may take up their affidavit. It is filed on 27th of May.
Yes, Mr. Naik, you will argue or Mr. Soike is.
Yes, Lordship, he will appear today, Lordship. If they are not filing any reply, Lordship, to my affidavit, Lordship, then Lordship will fix this matter for hearing. Hearing of any. Did they reply file for us?
I don't think so. Reply is called for. That is up to Mr. Monto again.
Reply now.
After vacation. After vacation. And after vacation,
What I find, my lord, immediately, what I find, my lordship may say, because they have themselves said they needed 15 days time. Let them come up with what they say, want to say here at page 436, lordship may kindly see that affidavit, their affidavit,
The latest one.
latest one, which they have submitted. Last part of the paragraph 3 at page 436, last paragraph. In this regard, it is stated that the recruitment process in terms of the notice dated such and such is under process and likely to.
But again, if that is, that will not help all the petitioners.
No.
It
That is
will only
why.
be limited to 47.
Why? That is, my lord, that cannot.
Because they say that you have not submitted your applications online.
Yes, because that has not been made open to us. We could not. Because system didn't accept it.
Accepted.
That is the difficulty.
But we had passed orders
Yes.
in similar matters. Yes,
Similar
Mr.
because there was already order passed. In our affidavit filed on 1st of April, lordship will find that order we have given. It was the order dated 8/8/2023. Passed in WPC 70.
My Lord Justice made his order.
Yes.
Wow. Yes. Yes, absolutely.
So.
When should we fix it?
What should we fix it next week? Or,
Motion.
yeah.
Immediately on reopening
Yeah.
would be better.
Because
As agreed to by the Islamic Council for the parties, registry to list this matter again. Immediately after the ensuing summer break.
we fix a date, my lord, so that.
Want a date?
Yes.
So the Islamic Council of parties has briefed that this court would be pleased to
July
take up this matter on
18th or 17th, 18th?
18th of July, 18/7/2024.
All right.
Ketas hai motion. Orders ketas. Basis. Second.
Same prayer. Same prayer Mr. Nair, sir.
More prayer.
Same prayer as Mr. Nair. Mo Nair ko na same prayer. I'm a prayer bolo then. Has requested Mr. AZ.
No.
That is a difficulty only I'm facing. And this second half lordship is
No problem.
especially.
No problem. No problem.
Lordship has given us direction to give the points. Lordship, I have highlighted 3 pages.
You do one thing. When the matter is taken up for final disposal, you give me that because Mr. AG is not here, so we not take up the matter today.
Lordship, this has been going on, Lordship. If a Lordship
Otherwise,
takes
there is
an
no
order-
urgency lordship because their main apprehension that
I've,
they were all
I've
promoted.
got your prayer.
Yes.
I'm accepting your prayer.
Yes.
Heard Mr. SK Das, Learned Counsel for the petitioner, and also Mr. TSMT Sisti, Learned Counsel appearing for the respondents. So it is submitted at the bar that the matter would be argued on behalf of the state respondents by the Learned AG, who is not available, who is today engaged in some other matter.
Yes.
Also, accordingly, registry to list this matter again immediately after vacation.
Yes, Lord.
On 16th.
Not 16, Lordship.
Then 18, 23, 23,
Oblige you.
23, sorry.
Lordship, hearing this matter, Lordship, by the order dated 3/6/2024, Lordship, the secretary was directed to file an affidavit, Lordship. Though the director of higher education has already filed, Lordship, but his affidavit is required, Lordship. But Lordship, I am yet to receive instruction on his behalf, Lordship.
Yes. He has already made an inquiry in the matter, so he has the points with him. So why is the delay in filing an affidavit?
Give some time, Lordship.
Give him a week site.
The date may be faithful.
Mr. D. Pomenu, Learned Counsel, Standing Counsel, Senior Higher Education Department submits that he be granted further 2 weeks time to bring on record the affidavit on behalf of the Secretary of the Department as ordered by this court-wide order, as directed by this court-wide order dated 3/6/2024. Full stop. Mr. S. Thump, Learned Counsel for the petitioner, does not object to the said prayer so made by the Learned Counsel appearing for the respondents. Full stop. Accordingly, registry to list this matter on 26/7/2024. It is directed that before the returnable date, the affidavit as directed by this court-wide order dated 3/6/2024 shall be filed in the matter by the Secretary, Higher Education Department.
Highly obliged. Three lawsuits, in this case, we have filed our affidavit just today, lawsuit. I think it is not to the record.
It
Let
is
come
submitted
after.
by Mr. B. SMT Sisti. You have got a copy?
Yes, Lordship.
Yes.
I have.
SMT Sisti that an affidavit has been filed on behalf of the state respondents in the matter. Also, registry, however, the same is not tagged with the records of the case. Registry to trace and tag the said affidavit along with this case and list the matter after the ensuing vacations
Any date may be given. I am not getting personal verifications.
on 22/7/2024.
Obliged, Lordship.
Yes, Mr. Khandagar.
In this case, no affidavit has been filed.
What about your land documents?
Land, my lord, in fact, there was government land.
Then?
My lord, the land advisory committee already passed.
Then the order is not wrong.
Even my lord. In
Then
the-
why should we entertain this?
That, my lord.
Because that is one of the conditions.
One of the conditions, otherwise, my lord.
Anyway, before vacations, I'll not trouble you.
But other schools considered, my lord, from the same.
Forget other schools. Whatever issue is before us, they are right in requiring the school to have a particular dimension of land. Because that land will vest in the government, right? They're going to pay you everything. So this much requirement can't the government have? That the school should have a land of its own. If you don't have a land, you're not covered by the 2017 Act.
But since 1984.
You show me how can I go beyond the Act? No affidavit is required.
Because my
I don't
last-
want your clients to be troubling you during your vacations. That's why I'm adjourning the matter. As prayed for by the learned counsel for the petitioner, list this matter again on 17/7/2020.
Can you
Next
tell me
day.
After 20.
22nd. Next
I'm-
day we are dismissing it if you can show it.
I am only.
Yes.
In this case, lordship, the affidavit has been filed by the BTC
My lord,
lordship.
somehow, my lord, affidavit filed by BTC.
Hmm.
And my friend appearing for the respondent has not been served, my lord. He, lordship posted any other time in the meantime.
Why should he be served?
He a Kaksu.
Why should he?
Private respondent. my lord. He was
Katsi Sheikh,
No, I have,
you have got the affidavit.
In my case, it will not file. No, one case I have the file that will cover all the things.
Giving copies.
Lordship.
Mr. S. Bora, learned counsel for the standing counsel BTC submits that an affidavit has been filed in WPC
45.
45
45.
oblique 2024 and the same is stated as same is contented to cover the issues arising in WPC number 48 2024 and WPC number 421 2024. So Mr. Bora is directed to serve copies of the same on the learned counsels appearing in the other two writ petitions. So accordingly, list this matter after the ensuing vacations. The petitioners are at liberty to bring on record rejoinder, if any, to the said affidavit.
a copy may be served.
No, I will file, I will serve.
But to the petitioners as well as the counsel for the private respondents. Yes, Mr. Sisti, what has happened? What development?
Mr. Khatonia has listed here, lordship, that I have received an instruction.
Implemented.
No, lordships. Difficulty that lordship, the finance department has sought views of judicial and department and advised to resubmit the proposal with.
That is, we have it from May. What is the subsequent development?
Lordship,
Mr. SMT Sisti,
NJ Khatonia, lordship, I am not in this, he has just requested me to appear.
Mr. SMT Sisti submits that the matter pertaining to implementation of the directions passed by this court, violation of which is alleged in the present proceeding, is under active consideration and prays that he be given 2 weeks' time to bring on record the developments as taking place in the matter. Full stop. Prayer accepted. Release this matter again after 2 weeks on a late to be fixed by the registry.
22. I'm out.
Lordship, here I was supposed to
Family pension.
family pension given. Lordship, the department has asked for some more time. Lord.
Why? Yes,
My lordship, my senior is on lags at.
on the prayer made on behalf of the parties, list this matter again after 2
Lordship.
weeks.
Just my friend has given an.
You have paid him.
For aging.
You don't know, AG knows.
Yes.
Huh? Yes, council, payments have been, PPA has been issued.
My lord, my senior is on.
Who is your senior?
Jason, Mr. Jason,
Call him.
for the time being.
When did the man die? Fourteen. Took you 10 years. 10 years to settle the pension. Why? Why? What should we do? The Learned Council for the AG Assam has placed before this court the pension payment order issued in favor of the petitioner hearing in respect of the services rendered by his father, late Uttam Basfur. So, it is seen from the records that the father of the petitioner had died on 1/5/2014. However, the pension was settled only on 25/2014, that is nearly after a period of 10 years from the date of death of the father. Also, accordingly, the Director, State Council of Educational Research and Training, Assam, is directed to carry out an inquiry to ascertain as to for whose default the delay in finalizing the pension and pensionary benefits of the petitioner for the pension and pensionary benefits in respect of the petitioner hearing had so occasioned. Also, the Director SCRT shall on the next day place a report in the matter identifying the authorities who had contributed to the delay in finalizing the pension and pensionary benefits of the petitioner hearing. Also, the above aspect of the matter is being examined for the purpose of authorizing to the petitioner interest as prayed for interest for delayed payment of pension as prayed for in the writ petition. You get that?
Yes, sir.
Mr. Chaudhary shall communicate a copy of this order to the Director SCRT for doing the needful.
In this color, the report was called from the SSA. We have received the report. We'll be placing it before the next SLC meeting. The petitioner's claimant for consideration.
Mr. B. Kaushik, Learned Counsel, appearing for the respondents, has submitted that the matter has been processed and would be placed before the next placed in the next sitting of the state level scrutiny committee for consideration of for scrutiny of the case of the petitioner for provincialization of his services under the Act of 2017. Pura likhi diyo. So accordingly, raised it to list this matter after 2 weeks on a date to be fixed by it. On the next date of listing, Mr. Kaushik shall place before this court the minutes of the SLC meeting pertaining to the petitioner hearing. Pertaining to the consideration made in respect of the petitioner hearing. 2 weeks. 2 weeks to 3 weeks. After the vacation, like, date did you? By strike money. By strike here, go item number 52. Yes.
The class purpose and opposite party also take time to obtain instruction.
My lord, here.
You have received the proposal.
No, my lord.
Why?
Physical, my lord, only online that application has received, but physical copy yet to be submitted by the concerned inspector as on that inspection.
Yes, Mr. Sharma.
My lord, here director has written to the inspector to meet the objection raised by the petitioner.
Petitioner, a pension.
Sometimes it's written.
Petitioner, what objection she has raised?
Here it is written. In this regard, you are requested to meet up the objection raised by the petitioner as per rule and procedure and submit instruction directly to the senior standing council, education department, Guwahati.
Who is to submit? Yeah.
Inspector is the matter. Yes. Objection raised by the petitioner, make the objection petition. No, director. Objection.
Great. Keep it with you. If I start going against this with this, it will be a problem for you. Mr. U. Sharma, Learned Counsel, appearing for the Secondary Education Department, submits that he be given 2 weeks' time to complete his instructions in the matter. Full stop. It is submitted complete his instructions in the matter. Accordingly, registry to list this matter immediately on conclusion of immediately after 2 weeks. On a date to be fixed by it.
Date is your lordship. In the last provision,
Mhm.
was pleased to ask the.
We had given an opportunity to Miss Madam Bora. She seems to be not here today. Otherwise, your case is covered by Jigya Yadav.
My
We just wanted a clarification because an affidavit is not filed. We'll have it next week. Miss R. Bora, Learned Standing Counsel.
He has just called me that she has asked me to take time in this case. If he has some-
On a prayer made on behalf of Miss MS R. Bora, Learned Standing Counsel, CBSE, raised you to list this matter again. When? After vacation? Immediately on reopening after the ensuing vacations.
Obliged. Highly obliged.
My lord, here sometime is required, my lord.
Lord, several occasions, my lord, they have, they took time, my lord. Now, the petitioners, they are working since 2013. They are not, my lord, paid a single penny, despite the honorable court's order.
This was the second round of litigation.
This is fourth round of litigation, my lord. And the, my lord, order, which has been violated by the, my lord, respondent authorities, that your lordship will find at page 40. The operative part lordship will find at page 50, last paragraph. Page 50, last paragraph. Service was provincialized, then it was.
Yes, what is the problem? Mr. Sharma,
My lord, regarding the release of salary, my lord, so sometime.
have you filed an appeal against this?
Oh, my lord,
No,
still not done. My lord, maybe 3 weeks, maybe.
Page
then.
50, my lord, paragraph 22.
Why for 3 weeks? I'll give you 6 weeks. I'll give you 2 months, no problem. But show me what you have done.
My lord, department probably go filing in the review, my lord.
Now,
Yes.
after 23, 1 year. After 1 year, you were sleeping. Register to list this matter again. on 27/6/2024, on which date Mr. U. Sharma shall place on record the processing made by the department with regard to implementation of the directions passed by this court-wide order dated 1/12/2023 in WPC number 6147/2022. Just get me the processing that you're doing.
Obliged. My lord, a very unfortunate affair, my lord. In this content, my lord, may kindly peruse page 30. My lord. There is a direction for release of my current salary within a period of 10 days, my lord. Long back, my lord, on January, this order was passed. But till date, my lord, it has not been complied with, my lord. Page 30, my lord. And against this, my lord, a review was also filed by the private respondent. That has also been, my lord, closed, my lord.
Huh?
My lord.
By me only, Mr. Hawk had filed. You had filed.
No, my- no,
You had not filed.
my lord, Mr. Chaudhary appeared, my lord, in that review petition. For the
Now, wait.
private-
Have the services been complete?
That's the problem, my lord, does it complete? Respondent 4 appeared, my lord, but the
You
rest,
take fresh steps. 4 appeared.
my lord.
4 is for, 4 is the,
He was the earlier Geo Mallet, now
Geo.
transferred Mallet and posted as a promoted Mallet. Disciplinary for Mallet. Presently, he is not holding that post.
same the office note dated 18/6/2024, which reflects that the service upon the respondents number 1, 2, and 3 have not been completed. Steps in the matter was taken by the notices were issued to the said respondents on 3/4/2024. Accordingly, the petitioner is directed to take fresh steps for service of notice upon the respondents number
1 to 3, my lord.
1, 2, just a minute, and 3 by registered post with AD, steps within 3 working days from today. Registry to list this matter again after 4 weeks with a report regarding the status of service of notice upon the said respondents.
Lord, may I have a small prayer, my lord? This content can be tagged along with the main writ petition which is pending, my lord.
It will may then have to be diluted again. Let's see our directions, how we can do it. We'll do it.
Obliged.
May I please, Lord? Also, in this case, I am appearing for respondent number 7, Lordship. I have filed my affidavit, but that is not on record, Lordship.
Your affidavit has come.
Come, Lordship.
Private respondents affidavit, petitioner's dusty service affidavit has come.
Yes, that is there, but my affidavit, I am for the respondent number 7, that is not there. I have filed it on 31/5, Lordship.
Who is 6?
6 is the
You
headmistress.
both are the
No,
same.
Lordship, I am only for 7. I think they have served by dusty service, Lordship. The service is
Full stop.
complete.
Seen the affidavit. Full stop. The petitioner has filed an affidavit on 29/4/2024, bringing on record the service affected upon the respondent number 6 and 7 by way of dusty mode. Full stop. Accordingly, the service upon the said respondents number 6 and 7 is held to be complete. Full stop. Mr.
M. Ahmed.
M. Ahmed, Learned Counsel, has entered appearance for the respondent number 7 and submits that an affidavit in the matter on behalf of the said respondent has already been filed on
31/5.
31/5/2024. Full stop. However, the said affidavit is not tagged to the records of the present matter. Full stop. The registry to take trace and tag the said affidavit along with the records of the case and list the matter after 2 weeks on date to fix by it.
Lordship, can a date be fixed, Lordship?
After 2 weeks, make a mention.
Because there is some urgency. Because they have come for no confidence and my already state, Lordship.
Can it be in the third week of July?
Okay,
After the vacation.
okay, let's see what it is. Who are you?
I am the respondent number.
Lutfur Rahman. You were selected as nominated as the
President.
president of the college. Where is the
Not college.
school, primary school? Where is the minutes
Mine
of your selection?
That is, they have not.
You have it? You have it?
Okay.
Show me your affidavit. Show me your affidavit.
No, no, that
How
is-
were you nominated? How were you nominated as the president?
nom-
You are the president.
Yes, Lordship.
How were you nominated?
Nominated as a guardian of a student. Lordship.
Okay, school had nominated you.
Yes.
Where is that nomination?
That is. That that resolutions is not with me, Lordship. There will be after vacation. Lordship.
No, today itself. You have expressed an urgency, we will consider. Why? We have enough time today. 4:45. Enough time.
No, I would like to bring that.
You give me a copy.
No, no, that is
That'll-
not annexed with my affidavit. Lordship.
This will do. Okay, then what happened on 29th? 4.
29.
Okay. As direction so and so have taken steps to convene a meeting at the school managing committee in the office chamber. Consider with 6 so and so out of which program is elected. Elect 9 members. Out of 9 members, 6 numbers are present, 2 number applications are received and 2 number members in English also. I asked to place the latest status on as raised by them by submitting all the members are submitted petition. 9 members are waiting is also meeting and no one is denied with. One has met with one and meeting with one. And the meeting